Prior.
Medina?
Yes, sir.
Okay, you're gonna go in the first set of chairs behind the wall. You're gonna sit in seat number 2. Royer, there's a seat between you and Mr. Medina. Gonna sit in that fourth chair.
5.
Aroha,
Yes.
you're gonna sit next to Mr. Royer. And Dies,
Yeah.
right there. There's a seat between you and Mr. Aroha. No, Mr. Aroha, you're gonna sit next to Mr. Royer. Yeah, now you're gonna sit right there. And as McMurray, you're gonna sit in that first chair, in the first set of chairs. Yes, sit right there. Mr. Ferguson, you're gonna sit next to her. Ms. Diaz, you're gonna sit next to Mr. Ferguson. Mr. Rosetta, you're gonna sit next to Ms. Diaz. She's just sat down. Ms. Charles, you're gonna sit next to Mr. Rosetta first. And Mr. Travis, you're gonna sit next to Ms. Charles. Palermo, you're gonna sit right there next to Mr. Travis. Okay, Ms. Wyatt, you're gonna walk down that second row, right there, all the way to that first chair by the wall. And you're gonna, Ms. Leday, you're gonna sit next to Ms. Wyatt, who's walking down there. She's gonna sit in the first chair. You sit in the second chair. Ms. Collins, follow Ms. Leday. You're gonna sit next to Ms. Leday. Mr. Zachary, you're gonna sit on the second row. You're gonna follow Ms. Collins and sit next to Ms. Collins. Mr. Barber, you're gonna sit next to Mr. Zachary. And Ms. Bud Smith, you will sit next to Mr. Barber. All the way down. Okay, make sure we got the one. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. Now, you have been asked to come to court today for a criminal case. First of all, before we get started, I'd like to welcome each and every one of you to County Court at Law Number 2. Excuse me. You have been called for jury duty on today's date. You will be examined for inclusion on a jury trial, which is a criminal jury trial. Our courtroom hours vary, but they are normally from 9 to 5 p.m. Whether you are selected as a juror today or not, you're performing a significant service which only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless otherwise instructed, you will be permitted to separate yourselves for recess, for meals, and at night. Now, at this time, I must administer to you the first of 2 oaths. Now, I need each and every one of you to raise your right hand. And when I finish administering the oath, please say, I do. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching your service and qualifications as a juror, so help you God? Okay, you may put your hands down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a jury, a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you have been seated on a jury, the case could be retried, and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, I'm going to ask you a series of questions. I do not want you to answer those questions out aloud. Once I finish asking the final question on this in the series of questions, I will then ask you, is anyone disqualified under the law? And if you think that you may be disqualified under the law, then I will ask that you will come up before the bench outside the presence of the other jurors so that they cannot hear the discussion on that matter. Now, again, I'm going to ask a series of questions. I do not want you to answer those questions out aloud. Just answer them, each question to yourself. And when I finish, I will ask you, is anyone disqualified under the law? If you think you're disqualified under the law, you raise your hand, and then we will ask that you will come up before the bench. First question, except for failure to register, are you a qualified voter in Jefferson County and the state of Texas under the Constitution and laws of the state of Texas? Have you ever been convicted of theft or felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I usually pause before this next question, and just to let you know that by law, I'm required to ask this question. I'm not trying to meddle into your personal affairs. And the next question is as follows. Are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? And this is the last question. Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Is anyone disqualified under the law? If you think that you may be disqualified under the law, please raise your right hand. Let the record reflect that no one on the panel raised their hand. Now I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you're not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just continue to be seated. Now, I will ask these questions in the same manner that I asked the previous set of questions. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12 years, and jury service would necessitate leaving the child or children without adequate supervision. Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the 3-year period before today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States military forces serving active duties and deployed to a location away from your home station in Jefferson County? Is there anyone on the panel who would like to claim one of the previous mentioned exemptions? Okay. Okay, let the record reflect that we have juror number 12. That's correct. Juror number 12, Miss Charles, you can come forward. Ooh. You ready? Okay, ladies and gentlemen, now we'll move to excuses. If any of you would like to claim any of the excuses that I will mention once I finish mentioning or stating the three excuses, just please raise your hand and then we'll bring you up individually. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the state and without the consent of the defense. And this is the final statement. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to exercise an excuse? Okay. Let the record reflect that we have juror number 8 and Ms. McMurray. Would you please come forward? You'll stand on that side. Hold on a minute. Okay, let the record reflect that no other jurors are claiming an excuse. No other jurors are claiming an exemption. And all remaining members of the panel are qualified to serve as jurors in this case. Let the record reflect that the court convened this case, and this case is cause number 25 CCCR 1636. The case is styled State of Texas versus Makara Kane. Let the record reflect that the defendant, counsel for the defendant, and counsel for the state, and all members of the jury panel are present. And again, ladies and gentlemen, I just need to mention that you have been summoned to this court as a prospective juror in a criminal case. The defendant, Makara Kane, and Mr. Kane is represented in his case by his attorney, Attorney Langston Adams. The state is represented by Assistant Criminal District Attorneys, Attorney Cornelius Wiggins, who's sitting first chair.
Good afternoon. Good afternoon. And I'll be joined by my co-counsel on this matter, Mr. Robert Shane Middleton.
Okay.
Good afternoon.
I can. Well,
Oh.
again, my name is Langston Adams, I'm sorry. And then, my client to my right is Baccarat Khan, and he's here. You know, yes, you know, I don't know.
Okay. Okay, y'all may be seated. Our court reporter will be taking down everything being said, so speak up when you're answering or asking questions. Now, the defendant stands charged by information with the Class B misdemeanor offense of theft of property that have value greater than or equal to $100, but less than $750. And the punishment range, if the defendant is convicted, is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or the defendant can be given both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, backgrounds, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but is trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so. And I will ask you to come up to the bench so that we may discuss the matter privately. Is the state ready to proceed?
State is ready to proceed, Your Honor, with one brief caveat, and that would be a 3-minute recess, Judge.
Okay, that's fine. And the defense, you'll be ready to proceed after the recess?
I'm ready.
Okay, y'all may be seated. You're gonna take a 3-minute recess?
Yes, sir. Judge.
That's fine.
And Judge, just before we get started, the defense at this time wishes to invoke the rule for no witnesses to be at all when we're in the courtroom.
Well, actually, Your Honor, during voir dire, it is not an adversarial. I mean, while it's an adversary proceeding, Judge, there's nothing in reference to the testimony, and the witnesses would have to be here in order to see if the juries know like those people, Judge. There's nothing testimonial, Your Honor, to why the rule would be invoked at this time.
Again, specifically to the defense, it is proper for counsel to ask if you have a witness present. But part of voir dire is he's going to be going into his particular strategy as well as mine. And for a juror to speak, for a witness to be present during that process unfairly tips them to what the defense's strategy is. And that would totally defeat the whole idea of invoking the rules saying that the witnesses couldn't be present. You'll totally defeat that, because part of voir dire is he's going to talk to the jury about his theory of the case. I'm going to talk to the jury about my theory of the case. The witnesses shouldn't be talking to each other. And if they're in the courtroom, they're listening to all of that. And that unduly prejudices my client. And at the end of the day, normally it's been my experiences that witnesses are not in the courtroom during voir dire. And it's very rare. I haven't seen that.
Unless it's an expert.
There's no reason for witnesses to be in here. Now, he wanna ask about names. Do you know John Doe? Do you know Scott Doe? Do you know Susie Doe? It's fair for him to do that. But to have Susie Doe sitting right here, listening to my board Dyer, that unfairly prejudices him. They should not be discussing anything about the case.
I will say this, Your Honor, if his theory of voir dire is to put on particular like theories and stuff of his case, then that would be an improper voir dire. The only thing that we're supposed to do at this juncture, Your Honor, is to be able to determine if members of the jury can be fair and impartial. There is nothing in reference to case theory, particular facts about the case, Your Honor, that will come out during voir dire. Therefore, Rule 615 would be improper to be invoked during voir dire, Your Honor.
Judge, specifically, I think that's a misstatement of the law. The law is clear that you can go into a brief recitation of the facts of a particular case and board not brief. And you can also go into your defensive theories. And whatever my defensive theories are, the witnesses aren't entitled to know that until they take the stand. And that's absolutely unfair to my client.
Okay.
They shouldn't be in here.
Okay, this is what the court is gonna do. The court is going to allow the witness to just come in and to see if the somebody on the panel know him, and they would have to exit. Okay?
Thank you, Your Honor. So that, just for the record, that's a denial of the state's request.
Yes.
Thank you, Your Honor.
Well, partial did.
Well,
That's a denial.
Yeah,
So
but what we're gonna do is that if
you're allowing Rule 615 to be invoked, is that what the court saying?
what I'm saying is we're going to allow the witness to come in and because as you stated, you just want to know if anybody on the panel knows any of these witnesses. And so they may not know the name, but they may know the face.
Correct.
And so they'll come in and see if they know the face. If not, then they can go out. There's no other reason why they should be in the courtroom.
I totally agree.
Okay.
So Judge, do we need 3 minutes, or can we just do that now?
No. Well, that's he asked for the 3 minutes.
Correct, Judge.
Okay. Okay,
Thank you.
you're welcome. Is 30 minutes enough for each side, or if you need additional time, the court will give you additional time?
I think 30 minutes more.
You think 30 minutes is enough? Okay.
That's ample time.
Now, I'll keep the time. Well, what I'll do, I won't keep the time. And so, State, are you ready?
State's ready, Your Honor.
And you may proceed, Mr. Cornelius Williams.
Yeah, we're good. Thanks. Justice is a divine concept. Now, this concept is given from our Creator in the form of rules. Why? So we can get along with one another. These things are not embodied like within law. I, along with Shane, represent the state of Texas. Who is the state of Texas? It's not the government. The state of Texas is made up of the people. Who are the people? You all are the people. You all make up our community. And actions which happen within our community, we represent the people. This particular case, ladies and gentlemen, is a case of theft. We're going to say, why are we here on the theft case? Well, the reason that we're here on the theft case is because Mr. Khan has the absolute right to assert his being not guilty. We, the state, have the burden of proof. The burden of proof is beyond a reasonable doubt, and we welcome that burden. Here we are doing Badar. Badar is a French term, and all it means is to speak the truth. You know, the judge just gave you all an oath, and at this juncture, all you have to do is just be honest with us. Why do we ask you guys just to be honest? So we can see if there's any biases against, or prejudice against, or maybe even bias for. We'd like to know, let's say I hate broccoli, okay? So I got a bias against broccoli. If we have something that comes out in reference to a theft of the case or particular rules of law, we want to know if you're able to follow those rules of law, or there may be something about it through your own experiences to where you may not want to do that. That's what we're asking. That's what we're trying to ascertain, so that we know that Mr. Khan can have a fair jury, and we, the state, the people, can have a fair jury. So that's all that we need to know right now, is for you guys to speak the truth. Please participate. I'll ask some of your individual questions as we go along. Don't think for a moment now, if I sit there, if I don't answer, that I won't get picked. Well, we call this jury selection, although it's kind of like jury deselection. We will use what we call peremptory strikes to strike some people. Since everyone has already qualified, it is doubtful that there would be anything that would be up for cause. But should I ask a question, should you not wish to answer for the in front of the entire array, we'll approach the judge and we'll make the determination. So that we know, ladies and gentlemen, there are no wrong answers. It's like one of those general tests. Again, we just need to know what you guys think. Now, according to the Sixth Amendment, this is also why we're here. In all criminal proceedings, the accused, Mr. Khan, shall have enjoyed the right to a speedy and a public trial. Here we are. This is a public trial by an impartial jury, and that's why we ask about biases and prejudice. So you guys can be impartial. So it can be fair to Mr. Khan, so it can be fair to the state.
Hold on, Mr. Holmes, would you please let your client know that he can't talk during this time? You may proceed.
Thank you. An impartial jury is made up again by the community. What is the community? The community is the state and district wherein the crime occurred. Part of the elements that we have to show, it occurred here in Jefferson County. That's why we're here in Jefferson County Courthouse, ladies and gentlemen. he shall be informed of the nature and cause of the accusation. The nature and cause of the accusations that have been, and which was already shared previously will be called as discovery. All the information that the state has in its possession that we will use in order to show that Mr. Khan committed a crime has already been tendered. That's part tendered. It has been given over to the defense, so they can prepare a defense. He gets to be confronted with the witnesses against him, and ladies and gentlemen, we believe there may be 2 to 3 witnesses within this case, and able counsel for this defense get to cross-examine him. Why do we do this as part of like again the trial? Well, it is where we will call what the crucible of truth. We make a presentation, they get to cross, and you, should you be selected as jurors in the case, and to make a determination upon that. As part of it, he has a right to counsel, and that's what Mr. Adams is. Now, we'd like to know there's gonna be several people who may not testify. With that, we have members of the Groves Police Department. This incident happened in the Groves. With that, can we get Sergeant Robert Hancock, please? You may be in the jury room. Police Officer Joshua Berry. Mr. and Mrs. Topla Khan.
Judge,
Repeat that.
I'm sorry to interrupt you. It had nothing to do with your board doc, just a matter of forms, has nothing to do with you right now. Judge, I thought, just so we're clear, before we get in the board doc, doesn't he have opportunity to stand and plead not guilty? And have,
Yes.
and also have
That's
the
at the-
charging instrument read?
No,
Not yet.
that's after we pick the jury
Okay,
and we,
no problem.
yeah.
All right. I didn't mean to interrupt you.
It's quite all right, counsel. As I stated earlier, as we begin this, Mr. Khan sits before you all. I'm totally not guilty of anything. Why? No evidence has been presented. No evidence whatsoever has been presented. So he sits there before you just an accused. He is
Okay.
not guilty as we stand. Okay, ladies and gentlemen, we have Sergeant Robert Hancock of the Groves Police Department. Does anyone know Sergeant Hancock? That would be juror number 15?
Yes.
Let me ask you,
Yes.
Wyatt, and how do you know Sergeant Hancock?
No, we can do that. We can do that after they exit.
Yeah, I thought we just.
We just want to identify them at this point.
Does anyone know, Police Officer Joshua Berry of the Grove Police Department?
Okay, they can,
Okay, thank you. We anticipate, additionally, within this case, there will be, the complainant. The complainant would be,
I'm sorry.
the complainant would be Mr. Topla Khan. Does anyone know Mr. Topla Khan?
Judge, I'm gonna object now at this point. We made a big deal about pulling the witnesses so the jurors can see. He brought 2 police officers, but hey, if he's gonna do that, in fairness, the Khans who are the complainant, Mr. Khan, who is the complainant in this case, and then a witness would be Mrs. Khan, they need to be in here too.
Judge, they do not have to be here at this time.
Hold on,
because
hold on.
He can't have his cake. and eat
Mr.
it too.
Mr. Adams, please settle down. And Mr. Williams, would you please be quiet? Okay? Now, he has a right to ask the jurors if they know any of those witnesses, okay? And that's the furthest as we've gone. Okay, now at this time, Mr. Adams, you may be seated. It's overruled. Your objection is overruled.
I just want to make an objection. I haven't made official objection.
Okay, make your objection.
My official objection is by not having the Khans here, that defies the court specific order in front of this jury. And I ask for a ruling from the court to compel the state to bring the Khans here. The state argued that it wanted the jurors to see the faces of the witnesses. The state purposefully just brought 2 police officers, but the complainant and the complainant's wife, who they put up here, they didn't bring here. And what I'm saying is everybody in this court heard your order. So I'm asking you to compel the state by order of the court to follow your order and bring these 2 people in here like he did with everybody else.
Your Honor, Mr. Adams has no basis in law to impose a super burden upon the state. The Khans will be here, or Mr. Khan, the complainant, will be here to testify. It is a courtesy, Your Honor. The reason why we ask for the witness to come, once again, is the court is well aware. Judge, people know people by name, they also know them by face. If Mr. Khan was here, and maybe we're asking Mr. Topper Khan is outside, for him to come in for the jurors to see. Judge, he does not need to be here until he's actually called at trial. That is improper, and Mr. Adams has no basis to try to place a super burden upon the state, Judge.
That's a misstatement of what he did. He is the one who said, I wanted the jurors to see the witnesses. I didn't say that. He said that. So since he said it, he needs to do what he said. And he said, and bring the witnesses in. He's not.
Judge, that is
saying.
improper.
Okay.
I'm just saying.
That is
No,
improper, and I'm going to ask
Mr. Williams,
that the
hold on,
court-
Mr. Williams. He was talking.
If you
Now
make
allow him to finish talking, and then once he finished talking, you can talk.
as a matter
Hold
of
on,
fact,
hold
Judge,
on.
if he makes an objection, are we gonna have talking objections throughout this entire proceeding, Judge?
That's all he's been doing.
I haven't made a ruling, let him finish.
My point is, Judge, he asked for something. I did not ask for it. He is the one who asked of the court, hey, can the jurors see the witnesses in this case? And then your order was bring them in, look at them, if you know who they are, and then let them go out. He puts in a chart, he has 1, 2, 3, 4 witnesses, but then he turns around and only brings in 2. And what I'm saying is that you can't have your cake and eat it too. If you're gonna turn around and tell this jury, I want you to know and let me know if you know these people. Don't do it just for half. Do it for the whole. Don't ask for something and then turn around and don't do it. And that's fair.
Okay, Mr. Denise.
The state believes that, as I said earlier, we may have made a call, the witnesses, this is the proposed anticipated witness list. Now, does anyone know Mr. George Solis from the Groves Police Department?
Same objection. Where is he?
Judge, it's an improper objection, Your Honor. What is the basis of this objection?
Wait.
What is the objection?
Hold on. First of all, he made an objection to you not calling all the witnesses.
I didn't,
Okay.
Judge.
I never made a ruling.
To call the witnesses yet, Judge.
Listen. I never made a ruling, so you went on to the next witness. I wasn't finished. He wasn't finished. I wasn't finished. Okay? So I'm gonna make a ruling on his objection. The objection is overruled.
Thank you.
Okay? Now, the objection is overruled. Okay, you may be seated.
Just new objection. The new objection is failure to follow your order on George Solis.
The objection is overruled. Okay.
I want the record to be clear, Judge. Would you like to just restate your order? Because what he stated was your order, Judge, is improper. The court never ordered what Mr. Adams is stating that
I
the court
never
ordered.
said it was improper. I said, do what you said in front of all of these people that you didn't do. That's what I said.
Say he allowed to be able to call a witness so that they can, if they didn't know the name, they may know the face. That was that's what I said.
Correct.
So if he doesn't bring them in, that's not a violation of this order. I said he'll be allowed. I didn't order him to do it. It wasn't a court order.
Thank you, Your Honor.
Okay. Now you may proceed.
Thank you. Anyone knows Mr. Adams? Mr. Langston Adams? Yes, juror number. Is that Mr. Roy?
Yes.
And, okay, you know Mr. Adams. And what you know, and how do you know Mr. Adams?
For the company that I work for, I went to work on their conditioner before. don't know if I missed, I haven't met him face to face, we talked on the phone, I've met his wife, so.
Now, Mr. Roy, if I, you know, Mr. Adams and having worked on the air conditioner over by his home, would that affect you and your ability to judge the evidence in this case and be fair to both Mr. Khan and the state?
No, not necessarily.
Thank you very much. Anyone else knows Mr. Adams? Does anyone know Mr. Robert Shady Hilton? For the record, no panel, members of the panel said that they did, and does anyone know me or Cornelius Williams? Thank you. Once again, for the record, no affirmative no affirmative answers as to who you know. Now, members of the array, look at each other. Does any member of the array know any other member of the array? Once again, no recognition of each other at the panel. Now, here we are, we have the offense of theft is found in the Texas Penal Code as section 31.03, and the following essential elements the state must prove.
Mr. King,
beyond-
Yes. No,
please do not make any comments while we're in Bordeaux.
no.
Okay? You may
The
proceed.
state must prove the following essential elements beyond a reasonable doubt. One, the person who appropriated the property of another. What does that mean? Somebody took the property of another. Real simple. The second is that the appropriation was unlawful. Did the person have a right to take whatever it was? In this case, it would be a case of United States currency. Did he have the right to take it? And three, that the person did this with the intent to deprive the owner of the property. He took it, but wanted to keep it. Real simple. And actually, there's one other element, and that would be, did it occur here in Jefferson County, Texas? If the state's able to prove that beyond a reasonable doubt, then we will ask for you all to return a verdict of guilty. Now, here's the evidence in the case. We have direct evidence and circumstantial evidence. Direct evidence, I saw defendant take something. I saw the defendant take money. That's direct evidence, okay? And what you would do, should you be chosen, you will listen to the testimony from the stand. You alone are the judges of the credibility of witnesses, the credibility of their testimony. What weight, if anything, do you give that witness? It is up to you. It is a question of fact, okay? Members of the jury, should you be selected, you all make that determination. Through direct evidence, did this person see another person do it? Okay, another thing, I see it raining outside, okay? That is direct evidence. We have also what's called circumstantial evidence. Circumstantial evidence, you come inside the court, right? You go outside, you see the street paved in water, you see water all over the cars. Although you saw it did not rain, you know it rained, correct? How do we know it? Through circumstantial evidence. So now I ask you all, can you treat circumstantial and direct evidence exactly the same? I want y'all to look over at Dumpling. Dumpling is like the dog. Think about this. Y'all, if y'all have a pet, you leave him at home. Somehow he get out the cage, okay? And while you're not home, what does Dumpling do? He goes out, tear up the trash, tear up your couch. Now, you didn't see Dumpling do this, correct? But Dumpling was the only person within knowledge. You didn't see it. That is circumstantial evidence. So I ask you, juror number 2, Mr. Medina Ferrer, can you treat circumstantial evidence exactly the same as direct evidence. Can you, please enlighten us to why, if that is the law, and which it is the law, you must treat those two the same. Why can't you treat direct evidence, if you saw it, the same as circumstantial?
Well, I think substantial, I don't have the facts, I just make assumption based on the scene. Just like you used the example of the dog, I was witnessing the dog doing what he did, I just assumed. With the direct evidence, I saw the actual fact happening. That's why I don't think it needs to be treated the same.
So what you're telling us, so we're clear, is that you will not be able to follow the law because you cannot treat circumstantial and direct evidence the same, correct?
Well, I'm not sure if that's the law. My objection is that when he say to this juror, can you treat direct evidence versus circumstantial evidence equally the same? Well, they're not equally the same. In his video, we see the guy who is walking in the street. So we see that. You don't see the dog doing what the dog did. You assume that he did it. So I just want him to be, when he say treat them the same, I asked him to specifically go to the law that he's referring to.
Court is. Can't get that. The court is well aware, through the pattern jury instructions, that direct evidence and circumstantial evidence must be treated the same.
Did you say my objection, judge, is that what you?
Okay, what is the, you said, okay, now,
Just sit down.
okay, now, do you have what statute or the article? Let's see.
Judges within the court pattern jury instructions coming to direct,
Well,
I think
the court has the instructions before it, Judge, and the court can read, as the court will give you all, what the laws and the rules according to the case is.
Judge, I think specifically the law is that it's within the province of the jurors as the triers of fact, they determine the credibility and the weight to be given to testimony. The evidence. You can prove a case with circumstantial evidence, but it doesn't necessarily mean you're going to treat circumstantial evidence exactly the same as direct evidence. That's within the province of the jury to determine the weight and the credibility to give to testimony. And I think that is what's in the law. So he's misstating the law. That's not the law.
It is the law, Your Honor. He's mixing apples and, I don't know, rutabagas. Because for the simple point of it is, Judge, and the court is well aware, it's a part of the jury instructions, they will be instructed that while they give the weight is correct, Judge, but according to the law, it must be treated the same. Nobody is addressing the weight to be given to the testimony. That is up for them to decide. But as the law, circumstantial and direct evidence is the same, Judge.
I think you asked him for.
Okay, now, I think the way you explained it, obviously there's two different, first of all, there are two different types of evidence.
Correct, Your
Right.
Honor.
So one type is direct
Correct.
and the other type is circumstantial.
Yes, sir.
Okay. Direct evidence is not circumstantial evidence, and circumstantial evidence is not direct evidence. Right?
But the law.
There are
when you
two different
instructed-
types of evidence.
Judge, but they are supposed to be treated.
They'll be treated
Equally.
as evidence, but they're not the same. So what you're saying is you'll be treating them as evidence. One type is circumstantial and the other type is direct.
What the court is saying and what counsel is purposely, I'm gonna say it, Judge, purposely misleading the jury on. There is an absolute instruction to where circumstantial evidence must be viewed in the same light
Yes, okay,
as direct evidence. That's
Right.
what the court will
Right.
instruct. But according to, for counsel, Judge, if you're going to have a different circumstantial evidence should be what? More circumspect than direct evidence? And that is improper. That is not what the law states.
I don't think nobody said that. I think the way you explained it to him, was a little, I guess, confusing to, juror number, is that 2? I think that's what Mr. Adams is saying. I don't think he's saying that you cannot use circumstantial evidence in a case and you cannot use direct evidence in a case. I guess he's having a difficult time right now is trying to understand the difference between the two. And also, but we can move on because, if we need to take him, any other of the jurors on voir dire, we can do that.
Judge, one thing that has to be clear, what the state has to be able to like to make a record. If, juror number 2, if Mr. Medina Ferrer says, I cannot treat circumstantial evidence if I'm given the instruction the same as direct evidence. If that's his position, then that would be his answer, then I can move on.
Judge, I think I can clarify.
Okay, but we
Doing
can,
his he can.
and then we can also clarify that, as we continue along with voir dire, and usually what we usually do is at the end, we can bring each individual back in.
Judge, then I would have to, no, to answer, for the array. My next follow-up question would be, does any other member of the array agree with Mr. Medina Ferrer that they cannot, if instructed by the court, can you treat direct evidence and circumstantial evidence the same as that's been instructed? Or you agree with Mr. Medina Ferrer?
You wanna say?
Here another, Roy,
You wanna?
Mr.
Hold on,
Roy,
wait.
can,
Let him continue on his voir dire, Mr.
I just want.
I will overrule your objection.
Yeah, I think
what's your name, please?
Rubina.
That's juror number 5, Mr. Medina. And did you agree with, juror number, 2, Mr. Roy? And juror number, I'm sorry, juror number 17, Ms. Collins. You agree with Mr. Dina Ferrer? And juror number, is that Ms. Bud Smith? Juror number 20, and you agree with number 2 as well. So let me ask you this. Oh, I'm sorry, I did not see your juror number 14. And then it goes straight down. So let the state is clear. Mr. Ron, if you come in here, it rains outside. Okay, you did not see it rain. Everything is wet, cars are covered in rain. You cannot, what you're saying is, since you did not see it, you could not conclude beyond a reasonable doubt that it rained outside. Are you saying that because you didn't see it? Mr. Rojo? Mr. Rojo, same, you've been here, you walk outside, everything is wet. Are you telling, the court, you letting us know that you could not conclude beyond a reasonable doubt that it had rained outside? Mr. Palermo? As you sit in here, when you came in for jury duty, it was, dry outside. After, you go outside during the break and everything is wet, cars wet, street wet, you didn't see it rain, okay? But we know that it rained because everything is wet, correct?
That's correct. That's not what
But
the question is. That wasn't the question that matters.
the question, here's the question, and we will have, again, we'll have a chance to talk about it. Direct evidence is that you saw it rain. You did not see it, direct evidence, I see it rain, okay? I know that it rained. If you go outside, everything is wet, that is circumstantial evidence because you did not see it. Can you conclude, Mr. Palermo, beyond a reasonable doubt that it rained outside?
I can conclude it rained. That's way different than what we would be dealing with here.
Or
I don't
dog or
understand.
trash, dog, don't compare rain with the dog or trash. Yes, that's kind of.
Let me take a step back.
I think what everybody.
The reason-
Is that
Right.
you're telling us to agree with something beyond a reasonable doubt, but there's other factors that could have led to those same outcomes of those things happening. Somebody could have been outside with a water hose, went every car, went in the street. So many other things could have happened. I think everybody's just getting caught up on the
Well-
fact that you're telling us, say it's this, when it could be anything else. That could also cause.
So what you're saying is, well, then, again, just so that I'm clear, the court will give you an instruction that direct evidence, if I see it, is the same as circumstantial evidence. And you're saying that you cannot treat those two the same, correct?
No, we're not saying we can't treat it the same, we're just saying that you want us to say this happened because we just think that this happened, not, there's no evidence really concluded to that, that's the way that it presented it to us. But I do understand what you're saying, I know that, circumstantial evidence can also be the same, similar to, direct. But what we're saying is the way that you presented the question, the way that you brought it upon everybody, it makes it seem that you want us to make a decision based on our own thoughts. Because
Correct.
we might have seen, okay, this could have been the answer. So beyond a reasonable doubt, that's just what it is. And I think that's what everybody's getting stuck on.
Well, I thank you so very much for pointing that out. This would be Ms. Dice. I'm so glad, so now, this is why I ask you guys like again to where we speak the truth. The reason why I just gave an example, that was again of a dog, I'm trying to give an example of what is circumstantial evidence. Now, circumstantial, you would treat it differently, because if everything is wet outside, as you said, it could have been a water hose. Okay, well, if that is reasonable opposed to it being raining, you have the absolute right again to do that, okay? But the law will tell you that circumstantial evidence is to be treated the same as direct evidence. It should be treated as the same, okay? If I'm clear, Ms. Guys, so what you're saying, I would be more, well, not put words in mouth, so what you're saying is, if I don't see it, it could be anything else. And in a way, you cannot treat those two the same, can you?
Yes and no. I mean, you can, depending on how much evidence you have, circumstantial evidence you have to conclude that, I think what everybody's getting stuck on is, like I said, it's just the way that it was presented. I don't think it's so much, oh, we can't at all, none of us have the ability to treat it the same. It's more so you're asking this specific thing and you're saying, would you go out and say, yes, that's it? And a lot of people would, because that would be us going on our own understanding, which everybody have a different understanding of what it is.
What I want us to, okay, this is how I want to like to be clear. And I'm gonna make it again as succinct as I can. You're sitting here, Ms. Dias. It was dry outside. You go outside, and this is the very nature of circumstantial evidence, things that we do not see. If you go outside and everything is covered, maybe you will conclude that it's because of been a fire hose or whatever. But my example was all the cars, the stuff for wet, there raindrops and stuff on the car. So you say, you may come up with something else, okay? But beyond a reasonable doubt, you could not conclude that it rained. I'm not getting to the specific facts like of a case, but if you're telling us that you cannot conclude it's beyond a reasonable doubt, that's all that, what we need to know. And that's what you said, correct?
That's not what I'm saying. It's not what I'm
What
saying.
about,
I'm saying that I would take that, oh, it could have rained, it could have been a sprinkler, I'm not gonna just say directly, it rained.
Because somebody's life
That's
depending
like-
on it, I mean,
Exactly.
that every.
It's. But
I
I
wanna hear-
understand where you're getting at, I'm just telling you that the way that it's being presented, I think it's just getting caught up on the situation that you give, you gave with real life and like an actual court case. you can't just say, yes, that happened, because then if it's something else, then we just convicted somebody of a crime that they didn't commit.
It does tell in exactly what Mr. Medina says. Juror number 20, Ms. Bloodsmith, are you of the same opinion as juror number 2 and juror number 7? Just so that it's clear. The court will instruct you to treat those two the same. But given from our discourse, I thank you all for sharing. The state has a burden of proof. We must prove
No,
each and
Mr.
every element beyond.
Williams, right now you're at 35 minutes. You can
Well, Judge, you
continue.
talked-
No, I didn't, you didn't let me finish. You may continue.
Thank you, Your Honor. I'm just briefly going to touch on what it means beyond a reasonable doubt.
Yeah, okay.
I think that we have a pretty good idea. When it comes to circumstantial evidence, you guys may have a reasonable doubt if it indeed rained outside, because it could have been of something else. Reasonable doubt is not beyond all doubt. Okay? When you all approach a red, okay? Do you stop at a red light? Most people will say, yes, I did stop at a red light. When you proceed to a green light, do you stop at a green light, or do you proceed through on a green light? The reason why I point that out, when you're in a car, you have your family in a car, you have your friends in the car, you have your children in the car. Is it beyond a reasonable doubt when you proceed through that light on a green light that the car has the red light is going to stop? Okay? How many times do we know of car crashes? Okay? It's not beyond our doubt. People will run a red light. People will hit you. But we go beyond a reasonable doubt when we see a green light and go through. If it was by all doubt, we would stop because a car or an 18-wheeler, something could be coming and they run the red light. Ladies and gentlemen, reasonable doubt is not beyond all doubt. It's as simple as what choices do we make in our everyday affairs? Not all doubt. What is reasonable? And if the facts, again, are reasonable through circumstantial or direct evidence, then we believe that that should be enough for a reasonable doubt. Should y'all be chosen as a jury? Is there any other reasons that you guys think that you may not be able to serve? Is it by religious reasons you cannot serve, you cannot judge another person? Any member feel right? Does anyone have any doctor's appointments or anything that was going on today or impede them from carrying on the hearing? Finally, it's our position that this case should be resolved today. Does anyone have any objections to going past 5 o'clock? We think the case should be able to be wrapped up by 6 o'clock. Anyone up there, right? Yes, sir. Number 2, Mr. Medina Ferrer. Yes, sir, can you?
Yeah, absolutely. I would have to take my children to their basketball practice, their soccer practice. I'm the team manager,
What time?
6 o'clock.
It says 6, so you have to be there before 6,
Yes.
right?
It's next for me too. To get to mine, I'll have to sit there.
I think what we said is we'll stop by 6 and be done. So that's good, I think we stop at 6.
Yeah,
Don't, maybe go till 6 and stop at 6. Oh, no, I didn't hear you, I'm sorry. I didn't hear you, I'm sorry.
I have to pick him up from school at 5, to get out at 5, 9 to 5.
That is, Ms. Collins.
Yes, sir.
thank you, Pastor Willis.
Okay,
Pass the panel.
Mr. Williams and Mr. Adams, the court is gonna take a 5-minute, recess, 5 minutes. Will a panel exit the court? All stand as the panel exits the courtroom. You could go out either door.
Mr. Claremont.
I'm Slater, can I go? Yeah, thank you.
You may be seated. Okay, Mr. Adams, the panel is yours, Mr. Williams. If I'm not, I'm looking at, we had 39 minutes.
Right.
You may proceed.
Thank you, Your Honor. Holding counsel. Again, my name is Langston Adams. As I begin every board diary, I begin those board diaries scared. And the reason why I tell you that is that at the end of the day, you guys are gonna make a decision. You're gonna make an absolute decision. And in making that particular decision, you're gonna decide ultimately whether my client is guilty or not guilty of the charge of theft in which he's been charged, ultimately. And as a result of that being a Class B misdemeanor, he can get a fine, jail, or whatever was in the realm of the court in punishment under Texas law. And any person who's representing somebody when their liberty is on the line, you would want Mrs. What's your name right here? McMurray. Right, if I was representing you, wouldn't you want me to care about your case? Who would disagree with that? With that said, between all of the banter between me and opposing counsel, Mr. Williams, let me shock y'all by something, but totally shock you. Despite all that going back and forth, a lot of what he said, I agree with. And look, got you up, didn't it? Right? A lot of what he said, believe it or not, I agree with it. He gave me the courtesy, which he didn't have to do, of providing me with a copy of his board hour presentation. And that was the what do y'all call it? The computer program that they use? PowerPoint, that's it. The PowerPoint presentation. So I said, what he showed you, look at this. I got a copy of it. You didn't have to give me that copy. It was purely professional courtesy for them to do so. I say thank you, Mr. Williams, for that. You're welcome. Now, with that being said, he begins his board hour telling you all about speaking the truth. Y'all remember seeing this slide? See this slide right there? Right? And then the following slide, remember I told you much of what he said, I'm gonna agree with. The second slide he gave y'all is the United States Constitution 6th Amendment. That's what he put on the board. I didn't put that on the board, he did. And I'm showing you this slide, right? Right? And then when he puts that slide on the board, I highlighted something on here. One, in criminal prosecutions, the accused, which would be my client, has a right to a speedy and public trial. And the next thing, by an impartial what? Jury. So when we talk about impartiality, in my opinion, that's the whole point of voir dire. Whole point of it. Because it's his job and my job to kind of weed through and figure out who's gonna be impartial. Do you have a bias towards the what? Law. Can you follow the law, right? Or do you have a bias towards what? A person or a witness, right? Because obviously, Mr. what? Ferguson, right? Obviously, if the witness is your son, and your son is giving testimony in the case, we might think you're more likely to favor your son's testimony than anybody else, right? And if your son is a witness, then you might want to say, hey, I don't think I want Ferguson on the case, right? Okay, so let's deal with that part of it. It makes no sense to put up that chart where he had the two police officers who walked in here, the two people who didn't show up.
Objection, Judge. They did not have to show up, Judge. He's putting a super burden upon the state.
There's no
That was a
objection.
courtesy.
There's no objection that he's making. When he's
Judge,
talking
it is an
about-
objection, Judge, because he's placing a super burden upon the state that the state have to present every witness to come in here to court before the trial begins. They do not have to do that, Your Honor.
I'm only talking about your idea. You the one who said that.
Okay,
Can-
Judge, that is
hold on.
not the law.
we'll sustain it. Now, Mr. Adams, you may proceed.
Okay, so as I was saying, it was his idea.
And
I'm sure.
He's doing this-
Overruled you.
he hadn't said
He
anything.
just,
He just overruled him and he keeps talking.
he just sustained the
Oh,
objection.
Wait up, well, let me do this here. Now,
That's the state.
if,
That's the
you,
defendant,
oh,
to mislead.
okay, now, you know, the court can hold both of you in contempt of court. And the court does not have a problem with putting both of you in jail. Okay? So, Mr. Williams, you can take your seat. And Mr. Adams, you may proceed.
Thank you, Your Honor. So again, that was his idea. I'm talking about what he did. I have not.
Objection, Judge.
Okay, now, Mr. Adams, you can move on.
I'm trying.
Just move on away from that,
Okay,
Line.
so here's the point that I'm making. The point that I'm making is that when he's asking you about the police officers, then he's asking you about the complainants, right? Mr. Khan and Mrs. Khan, right? And I believe the last one was a Jurgensen, I might, the name, right? The point of doing that is to determine if you know them, and if you know them, to know whether or not you got what? A bias or prejudice, what? In front of them. That's the only point to have them come in here, right? There's no other point to do that. To determine if you got a bias or prejudice, where when you see Jurgensen, who's not here, right? Do I know him? Am I gonna be biased toward him? I'm gonna be unfair toward him. Does that make sense? So then let's go to the other part, and I think you did an excellent job of explaining it. Remember when he put up this chart? And I'm gonna go back to the first one. The dog chart. And that's what we got into our big old argument. Remember this? Right? And he was asking, hey, will you treat direct evidence and circumstantial evidence the exact same? And y'all got into y'all explanation of that, right? Remember all that big long thing we had? Hold on. Remember I told you as much I was gonna agree with him on. Hold on. I agree with him. The state can make its case using direct evidence. The state can make its case using what? Circumstantial evidence. But hold on, wait a minute. Who determines the credibility and the weight to be given to that evidence? You! Did you hear that again? So now hold on 1 second. Let's follow the logic of that truth, okay? All right? Okay? He explained to you. He showed you the picture with the camera and the camera showing this guy walking by in the picture. That's clearly direct evidence. Somebody is walking in front of the camera. We can look at the what? Camera, right? But hold on 1 second. The strength of that direct evidence may become weaker if we find out that, hey, they saying that you were walking in front of the camera, but nobody knew you had a what? Twin. Right? That could cause that direct evidence to all of a sudden get what? Weak. Yeah, weak. Circumstantial evidence. I think somebody brought out about, man, I can't remember who did it, but it was genius. I can't, whichever one of y'all did this, it was absolute genius. You thought about something that me as the lawyer didn't think about, all right? Let me tell you what you did. I can't remember which one. I can't remember if it was you who did this, or I can't remember, but here's what you did. You know, one of y'all said, hold on, when it comes to circumstantial evidence, and he kept on bringing up the thing about, well, if you find water on the ground suggests that it was what? Raining. Remember? Didn't he say it about 20 times? And then one of y'all said, well, hold on, Mr. Williams. Hit pause on that. How do you know your neighbor didn't what? Water the lawn. Did y'all hear that? So now wait a minute. Yes, you can prove a case with circumstantial evidence, but guess what? Your juror, the people who are sitting with you, said, "Well, hold on, Mr. Williams. If I see my neighbor's faucet, water hose dripping, it might not what." So at the end of the case, do you see the point that I'm making? Both direct evidence and circumstantial evidence, depending on what evidence is, could be what? WEAK. Weak. Do y'all see that? Do you see that? So now, let's get back to what he started with. Sixth Amendment. Remember, I'm using his chart. I mean, it's kind of hard. If I'm using and responding to what you put on the board, don't you think that's fair? If you put something on the board and my client is the one who's living his estate, can I use what you put on? So let's use what he put on. Where the crime shall have been committed, which district shall have been previously ascertained by law, to be informed of the nature and the cause of the accusation. Hit pause on that. The Sixth Amendment says he has a right to be what? Informed of the nature and the cause of the what? Accusation, right? So y'all tell me, how is he informed of that? Remember, he made a big deal about, oh, we got discovery, he sent you discovery. Okay, how does he get informed? What's the document that actually informs him of what he's looking at? You tell me. Somebody tell me, anybody. What's the document? I'll tell you. In a felony case, we would call that when the grand jury meet, they come back with a what? Indictment, right? So when they come back with that indictment, hold on for a second. You're gonna get the indictment that said, by and for the grand jurors of Jefferson County, we in county whatever day, do by say on blah, January or whatever, John Doe committed the offense. Yes, I'm just making this up. Murder, right? Well, now that piece of paper that we call an indictment, right? The defense gets to get that indictment. He gets that indictment, right? And now he's being told what's the nature and the allegations against who? Him, right? And then when he takes that indictment, he now prepares his what? His defense. Does that make sense? Okay, in a misdemeanor case, I'll show it to you. It's not an indictment, it's the information. This is the charging instrument. This is the charging instrument in this particular case. At the end of the day, the charging instrument in this particular case, where they are alleging that on the 12th day, 2025, didn't unlawfully appropriate property, some with United States currency of value of $100 or more, but less than $750 from William Can, the owner thereof, without the effective consent of said owner and with the intent to deprive the owner of that property. And then it says, against the peace and dignity of the state, signed one of their lawyers. So their lawyer signs this what? Information, right? All right. So now, this begins the process of letting us know, according to what he put on the board, the Sixth Amendment, he has a right to be what? Informed of the nature and the cause of what? Against him, right? Right? So now hold on. Remember, he took all that time, and I'll show it to you. He took all that time to tell y'all what was beyond the reasonable doubt. Remember that? He took all that time to talk to y'all about burdens of proof. Here's the chart. That's it right here. The same chart he gave y'all, right? So he's telling y'all, hold on. My information says to the defendant and now to you that Langston Adams Klein, Makai Corn, on June the 12th, 2025, did then and there unlawfully appropriate property, and I'm showing you what else he did. Look at this. Right. He put this chart up where he showed y'all about appropriate property, and he went into the took and the taking. Remember, he did all that, right? in this indictment, it says, hey, currency of value of 100 or more, but less than 750 from who? William Kahn, the owner thereof, without the effective consent of said owner and with the intent to deprive the owner of the property. So hold on. All of what they put in this what? Information. Beyond a reasonable doubt, he must what? Must prove. Right? Remember I told y'all I was gonna agree with him, right? I'm showing you I'm agreeing with him, aren't I? I'm saying, okay, this is what you said, right? So now based upon what you said, you gotta what? You gotta prove. Okay? So when we look at what you said, one of the things you turned around in this information and said is that he unlawfully appropriated property. So let's go by unlawfully appropriated. Can I steal my own stuff? Hold on, wait a minute. Y'all all see I'm using this computer. That's his computer, isn't it? Right? He went to the board, he had his presentation on his computer, right? I got my computer, all right? If I walk out of this courtroom with this laptop, I'm taking his computer, why not?
Yeah.
But hold on one second. If I walk out of this courtroom right now and walk out of here with this one, am I stealing anything?
No,
Why not?
because it's yours.
Because it's what? It's mine. So at the end of the day, would you agree with me that I can't unlawfully appropriate or take it illegally something that belongs to who?
You.
Y'all agree with that? So from the very part, they got to prove to you before we even get to anything else. They got to be able to prove to you that it wasn't what?
You.
So you got to be beyond any reasonable doubt. I didn't say shadow of a doubt. I said because I use his stuff, right? See, I like using people's own stuff because when you use their stuff, what they can complain about? So he has to convince you what? That the money in this case didn't really belong to who? And if he doesn't prove that, do you even get to any other steps? So the first thing off the bat, they must prove that the money in this case that was allegedly taken was not for my client. They don't get to that, they don't get to second base. So then now let's go to this. The currency of value of $100 or more, but less than 750. So you got a range. And here's your range. For this case to be a class what? B misdemeanor, he must prove that whatever money that was allegedly taken has to be between what? $100 to what? All right. Now hold on one second. If you make the determination, hey, I don't know if it was $1,000. I don't know if it was $20. I don't know. I don't know what the value was. Can you prove it beyond a reasonable doubt? That's a question. If you say to yourself, I really don't know what the value was. Can you say beyond a reasonable doubt it was between 100 and 750? Can you? Can you? Can you? Remember he talked about direct testimony, right? If there's conflicting as to what the value was, can he prove beyond a reasonable doubt? But let's go another step further. Direct testimony is Mr. Lawyer. Terrence, right? You saw I walked out, I almost walked out with my own computer, right? But let's change the facts. You change the facts. I picked this computer up and I walk out that door with this computer. Can you give direct evidence that Langston Adams walked out with the computer? From what you saw me pick it up and walk out. Can you say I saw it? Right? Well, in this case, I don't think there's gonna be one witness that's gonna say they saw my client take $1. Not one. With all people came, I don't think it's gonna be one that's gonna say, I saw him, like you saying, you can see me right now. Pick up this computer and walk out, right? I don't think it's gonna be one witness that's gonna say, I saw Khan go way over and take cash. What does that do to that witness? No, we talk about circumstantial evidence, right? Right? Would that strengthen circumstantial evidence, or would that what? Weaken circumstantial evidence? What would it do? But let's go forward. Because remember, let's hold him to what he told you, that I'm gonna prove these things beyond reasonable doubt. Here's the next thing, he gotta prove beyond reasonable doubt. He has to prove the unlawful appropriation, which he called the taking, right? He has to prove to you the value, but hold on. What's the third thing he has to prove? He has to prove that he took the money from who? William what? Khan. He got to prove that he took it from who? William Khan. That's what
That's
he indictment.
that's a misstatement of the law.
I'm just reading what's in the indictment. He put in the indictment from William Khan. I'm reading that word for word. So now hold on.
Clearly states that
hold on.
who has a greater right to the amount than for the defendant, for the property judge.
They put
No,
in.
well, hold on a minute. Now, what was your objection?
That what he stated was a misstatement of the law. All the people have to show is that Mr. Khan had a greater right to the property than a defendant. Yon, it's no different than a person who works at Dillard's. You use like the name for the person at Dillard's. If there's a class B shoplifting case judge, you'll say Susie McNamara. The property belonged to her. The property belonged to Dillard's judge. So
Okay,
you don't
now,
have to show, I'm just saying, and the law clearly states who has a greater right to the property. It's the people's position that it's Mr. Khan. It's a misstatement of law that I took it actually from Mr. Khan. That's a misstatement of the law.
okay,
Okay, can I finish?
now, no, before you go on, what's your response to his objection?
My response is what they plead, they must prove. And what in the example that he gave is absolutely doesn't apply. Yes, if can I make?
Yeah, I'm going on.
In his example, here's what he's saying. Somebody goes into Dillard, right? And while they're in Dillard department store, they steal a suit. Then in their information indictment, the person whose name that they put right here is the loss prevention officer who's representing Dillard. I totally get that, but this isn't a corporate case. This is a case where he's being accused of stealing money from his father. That's what they put in this indictment. So it's not a case where we got a Dillard and you got a corporate representative or you got the loss prevention guy. What they put is that he took $100 between $750 from, and they put a specific name. The name that they put on here is William Khan. So they need to be able to show that he took money not from Langston Adams, not from John Doe, not from the bailiff, but he took money from who? William what? Khan. That's what they put in the indictment. And as we know, once you plead, you must what? Prove. So, and then back to what he also put, he also, in this is that we have a right to be informed of the nature and the cause of the accusation. That's what he put under the Sixth Amendment. So he has a Sixth Amendment right. He has a Sixth Amendment right to know who he is being accused of taking money what? From.
Okay, now, Mr. Williams, I'm overrule your objection. You may go forward, Mr. Adams.
Did y'all get that? So hold on a second. Let's think this through for a second. You can be a direct witness. You see, me pick up this computer that don't belong to me, walk out that door, steal the computer. You see that with your own eyes. You see that, right? So what should we have in that case if Langston does that? Come now by the state of Texas, Jefferson County, Texas, hereby, blase, blah, blase, blah. Langston Adams appropriated with the intent, blase, blah, to take a computer from Jefferson County that wasn't lawfully what? His, right? The value of that computer is $1,000. It's a class A misdemeanor, right? Who is the person that's doing the stealing? Who? Langston Adams. Now hold on. Y'all saw Langston Adams steal the computer, right? Okay, but what if Langston Adams is the one who stole the computer, but in their information or indictment, they say, what's your name? Obina. Obina stole the computer. So now Obina is here on trial for stealing the what? Computer. And what's your name? Travis, right? But Travis testifies and says what? Langston is the one who stole the computer. Y'all gonna turn around and find Obina guilty? Would he be found guilty? I'm asking, would you find him guilty? Would you find him guilty? Yeah, for them. Would you find him guilty for them? How about you? 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 Because the reason you're not gonna find Obina guilty is the evidence showed who did the stealing. Langston. Do y'all follow that? So now hold on, wait a minute. That's Mr. Williams' computer, right? That's not Mr. Travis' computer, is it? So if we say the computer was stolen from Mr. Travis, is that correct? Who the computer was stolen from? So if they put on a piece of paper that it was stolen from whom? Then they got a problem. Do you see that? Because what they told you, they did not what? Prove. Y'all see that? Then here's the last part of it. That he did so without. Let me read word for word, because I don't want to get an objection. Without the effective consent of the said owner and with the intent to deprive the owner of the property. So you must have the what? Intent to do so. Now, my client has been making offers, right? I'm gonna ask y'all right now, will y'all hold this again? He does have no illness.
Objection, Judge.
Objection.
Objection, Judge.
Oh, okay.
Well, he does.
Hold on a minute.
Judge.
At this time, ladies and gentlemen, we're gonna take a break. Would you please follow the bailiff outside?
All right.
This here. Okay, ladies and gentlemen, at this time, mistrial has been declared, in this case. And that simply means that your jury, service is complete. And at this time, I would like to thank you for taking time out from your, busy schedules to be here, this afternoon. I know some of you came down and said, you know, I came all the way down here for a jury trial set through, I guess, 80% of the board hire, and I just wasted my time. Well, ladies and gentlemen, let me tell you this, you did not waste your time. And the reason why I can say that is because this case was one of several cases on our jury docket. Our jury docket started at 9 o'clock this morning. Okay. A lot of times, I think Mr. Adams, and I think Mr. Williams stated that, you know, a defendant, if he wants a trial, he has a right. He has a constitutional right to have a jury trial. A lot of times, before we even get to the jury trial, the state and the defense get together, negotiate, the state make an offer to the defense, and the defense bring it to their client, and the client can accept it or reject the offer. It is not uncommon for individuals to reject offers because they say, you know what, I don't think the jury's going to show up, or I don't think the witness is going to show up. But on days like today, when jury shows up and when witness shows up, a lot of time, individuals who reject the offer say, you know what, that offer that the state made to me a few months ago, it looks pretty good right now. Okay, and that's because of individuals like you show up. And this morning, I mentioned that we had several cases. Several cases was disposed of because they knew a jury was going to be here this afternoon to try their case, right? And so it's because of your presence, because of people who take time off from their busy schedules to come down here, we're able to move our docket. We can't move our docket without people like you. And so, on behalf of the state of Texas, behalf of the citizens here in Jefferson County, and behalf of the staff of County Court at Law Number 2, I'd like to thank you for coming down here this afternoon. Now, anytime that you're in the area of County Court at Law Number 2, you can come and have a seat in this courtroom. This is your courtroom. And the reason why I say that this is your courtroom, I know that when you came to court today, you was looking for County Court at Law Number 2. You looked over the top of the door and you said, this is County Court at Law Number 2. This is Judge Holmes' court. No, this is not my court. This is your court because this court belongs to the citizens of Jefferson County. You are the citizens of Jefferson County. This is your court. I'm only an humble public servant. So anytime you're in the area of County Court at Law Number 2, you can have a seat in your court and see what goes on. And I can assure you, you will find it very interesting. Now, you can sit in that same area that you're sitting in. We call that the peanut gallery. But you can't bring peanuts in here to eat because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and see what goes on. And again, ladies and gentlemen, I know we've been watching the news, and I know you've been hearing about COVID, and you've been hearing about the flu epidemic that is going throughout the country. Well, normally I would shake hands with everyone, but we can't do that under the circumstances. But I can give you what I call an air handshake. And so at this time, I like to give everyone an air handshake and thank you for coming down here to County Court at Law Number 2. Now, our court bailiff, she has some letters for you. You can get a letter and you'll be able to leave. Your jury service is complete. If you need any excuse or anything, our county clerk's district clerk's office is opening right across the hall. You can come, you can go to the district clerk's office and you can get whatever you need. If they can't give it to you, you come back here and we could give it to you. Okay? So again, ladies and gentlemen, thank you for coming down here. You're excused, and each and every one of you, please have a blessed day. Okay, you're excused.
Does you mind if we talk to him?
Oh, you can.
Awesome, you tell them. Oh, sorry.
And this would conclude the calling of the court's dockets on today in County Court at Law Number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.